Good. So I'm just going to take you to the final report. It's Core Bundle, tab 10, page 185.
Yeah.
And this is in the sort of summary section at the start. And you'll see conclusions, paragraphs 64 and 65, please.
Sorry, page?
Say page 185.
Do you have the electronic numbers to hand for the e-bundles? Because spectacularly, the electronic page numbers are,
Yes, again, don't comply with it.
well, it's not even remotely close. Page 185 is at page 211 electronically. I assume.
I was assuming it, I'm so sorry again. Can I give you the internal
No, it's
numbers?
okay. You just may have to bear with me a little bit because I'll be a bit
You
slow.
give the
getting
paragraph
to
numbers.
26.
Yeah, so it's page 20 internally.
Yeah.
Paragraphs 64 and 65.
Yeah.
So you see the conclusion that the merger has resulted in, maybe expect results in SLC, and then importantly, you'll see the finding in relation to limited alternative competitive constraints, which is what grounds 1 and 2 relate to. So this is when we come to look at the grounds 1 and 2. This is a material part of the final report. It's not, we're not in the periphery here. We're in the absolute heart of the findings. Just a quick word on the products. As you know, the case concerns dough to bake or DTB products, and it's necessary to distinguish between branded DTB products and private label or PL products. Just Roll, which is one of the merging parties, supplies branded DTB products to retailers. So you go into your supermarket and you'll see the label Just Roll, that's a branded product. And Cérélia supplies PL products to grocery retailers, so that's products sold under the retailer's own name. In relation to the nature of competition in this market, again, you can see that in the summary section. If we can go to paragraphs 33 to 36, which is page 179 of the hard bundle and page 14 internal numbering. I can ask you just to look through paragraphs 33 to 36, then I'll pick up some points from that.
Yeah.
So the theory of competition that the CMA's report is based on is as follows. You'll see paragraph 33, private label and branded products have very similar characteristics and are used by end consumers for the same purpose. Paragraph 35, the merging parties do not compete head-to-head in tenders. Again, in paragraph 35, grocery retailers have a finite amount of shelf space for DTB products, and there is competition between PL and branded products for that space. And then paragraph 36, that results in what is called cross-channel competition between suppliers of branded and PL products to win shelf space in the retailers. So that's the theory of competition that the report is based upon. So then let's turn to look at the alternative suppliers. If you go to paragraph 45, which is at page 181, hard copy, page 16 internal. And the CMA states, we have found that the competitive constraint on the parties from alternative suppliers is limited, both individually and in aggregate. The merged entity would be the largest supplier of DTB products to UK grocery retailers by a considerable margin, combining the first and second largest existing suppliers. The merged entity would face limited competition from other firms. Only two other suppliers, Bells and Hengline, which are both predominantly PL suppliers, with material shares of supply, and their shares are substantially lower than either of the parties. And as you know, our first two grounds of appeal concern the competitive constraints from Bells, ground 1, and Hengline, ground 2. And as I've already said, the CMA's conclusions on these alternatives form a material part of its finding that the merger gave rise to an SLC. I've already shown you paragraph 65 of the final report that refers to the limited alternative competition constraints. If I can just nail down that point by going to page 350 in the hard copy, which is page 185 in the original. Paragraphs 9.169 and 9.170. You see the heading Constraint from PL Suppliers. And then at 9.170, as set out in Chapter 7, there is competition both within the PL and branded channels and across the channels. Alternative PL suppliers may therefore provide an important constraint on Cérélia, because once a grocery retailer has decided to supply a PL, private label DTB product, alternative PL suppliers participate in the same tender processes as Cérélia, and they are in direct competition for the grocery retailer to select them as the PL supplier. So again, this is an important potential constraint. We're in the heart of the findings, not on the periphery. And then just to sum up on this brief introduction, if we go to I'm so sorry. That's right, it's potential competition. Yes.
It's entirely whether they do or not is a different question.
That's right. And that's what we're going to look at in grounds 1 and ground 2. But this whole thing is hypothetical in the sense that what you're looking at, if the merger is allowed, what would competition look like?
Yeah, sure.
So we're always in that world inevitably. So just to sum up, if we can go to page 398, paras 9.335 to 9.336, and that's page 233 of the internal numbering. If you read to yourselves 9.335 to 9.336, that emphasises the importance of cross-channel competition in the CMA's analysis, competition for shelf space. And then at 9.337, you'll see the conclusions in relation to alternative suppliers. So that sets the scene for grounds 1 and 2, and I'm going to move to ground 1 now. Our grounds of appeal are core bundle tab 2. Page 13, and ground 1 is the one that concerns Bells. So core bundle 2, page 13. The tribunal committed an error of law in concluding that the CMA's assessment of competition from rival contract manufacturer Bells was not irrational, ignoring clear errors in the CMA's assessment of the evidence. Now, during the investigation, Bells was awarded a significant PL contract, and you see that referenced. If we go to the final report, it's paragraph 9.177. I'll just get the page number for you. That's page 352, and the internal numbering is 187. Paragraph 9.177, there's some shading, so I'll ask you to read that paragraph to yourself, please. And that award of that contract materially increased Bell's market share. If you go to page 288, the internal numbering is page 123, and it's just above paragraph 9.9. It's table 9.1 I want to show you. It's the one that Justice Green was referring to earlier this morning. You have the table 9.1, shares of wholesale supply estimates for DTB products by value to grocery retailers. So these are composite figures for branded and PL products. And at the moment I'm interested in the Bell's figure. And you'll see its figure in 2021, 2022 and 2023. And the figure in 2023 is the result of the winning of the contract that we have just seen. Now, in spite of that development,
And just to be clear,
sorry.
Bell's is slightly shaded for the purpose of our analysis. To what extent are we allowed to refer to? We can refer to the range. Can we attribute it to Bell's? We can, I think, because it's the range.
That's my understanding. This is the CMA's shading, so that's why I'm happy to be guided.
They're nodding.
They are nodding.
Yeah,
So I think we can.
it's not shaded at 9.177, the paragraph that the friend just took you to, so that's the basis.
Thank you. So despite that development, you've seen the finding in relation to Bell's limited competitive constraint. If you go to paragraph 9.172 on page 351, which is internal page 186. And if you could read please 9.172 again, given the shading, I think it's easier if I just invite you to read it. And in the paragraphs that follow, you'll see the little subheading above 9.172, the evidence in relation to Bell's is set out, but I'm not going to take you through all of that in detail. And the evidence is set out up to paragraph 9.191, and then you'll see page 357, internal 192, the heading at the top of the page, our assessment. And if I can ask you to read the assessment, which is at 9.192 to 9.198, please. So those are the findings in relation to Bell's, and you'll see that the assessment is focused on 4 reasons, and let me just pick them out and identify them. First reason is Cérelia's internal views, and you see that in paragraph 9.192. Internal documents suggest Cérélia perceives Bell's as a constraint, although that evidence is mixed on the strength of this constraint. Secondly, retailers' views, and that's the second sentence of para 9.192. Evidence from retailers, except the two named, suggests that Bell's is not currently perceived as a strong alternative supplier. Third reason is market shares. You see that in paragraphs 9.193 to 9.194. And you'll see that the CMA recognised that Bell's might be able, so the potential point, to meet the private label needs of an additional large retailer in the short term. If it were to do so, its share of the market would approximately double. But the CMA says on that basis, Bell's would remain less than 1/4 of the size of the merged entity, which would hold a share of 50 to 60%. So third point is market shares. And the fourth point relied upon is the ability to expand. And that's paragraph 9.195. And you'll see the finding there. Now we submit that the CMA's reasoning is irrational for the following reasons. And in particular, I'm going to address you on Cérelia's internal views, the retailer's views, and market shares. And when we're looking at an assessment, you will no doubt bear in mind that when one is looking at the reasoning of the report, one has to look at it in the round. And I'm sure the CMA will remind you of that when they make their submissions, but that applies equally to the submissions I'm making. It may well be, in relation to each of these grounds, you think, well, that's not quite a knockout blow. That three taken together might sufficiently undermine the edifice to bring it down. So we are looking at this in the round. First of all, then, Cérelia's views. So that's paragraph 9.192. And you've seen that the CMA found that the views expressed in Cérelia's internal documents on the competitive constraint posed by Bell's is mixed. And in our submission, that's a patently inaccurate summary or conclusion of the evidence. And in our submission, the evidence overwhelmingly shows that Cérélia did consider Bell's to pose a competitive threat. And we can take that from...
That's what 192 says. It's Cérélia perceives Bell's as a constraint. It's mixed on the strength.
That's right. Well, I'm going to show you what the evidence is, and I'm going to make the submission that even as you just read it to me, which I accept as the correct reading, it's not an accurate reflection of the evidence.
Sorry, what's not accurate? The reference to it being mixed?
Yes, the evidence is mixed. I'm going to show you the evidence, and I'm going to show you that there's only one piece of evidence which is relied upon for that caveat, and it's just not worth the paper it's written on to make that point.
Right.
So the evidence is cited in the preceding paragraphs. If we go to paragraph 9.189, if I could ask you to read that, please. So what you'll see is that the FR cites from 5 documents covering the period from April 2018 to 2022, in which Cérélia referred to Bell's as a competitor. So that's one side of the equation. The other side of the equation is paragraph 9.190, so the next paragraph. And again, if I could ask you to read that, please. So you'll see that only one document is cited as supporting the contrary view, and therefore is supporting the reference to the evidence on the strength being mixed. And
Sorry, what about 9.191 and footnote 693? Is that part of the evidence relating to the mixed view of the extent of the threat?
well, that's in relation to just roles documents. So we're looking at Cérelia's internal documents because that's what the conclusion refers to, and GMI was the owner of just role. So I am taking the finding, which is based on Cérelia's internal documents, and these are the two paragraphs that are relevant to Cérelia's internal documents.
So is 191 not relevant at all?
Well, it's not relevant to the following sentence, the next sentence at 9.192, which is what the assessment is based on. The assessment isn't based on just roles internal documents, it's based on Cérelia's internal documents. And I don't want to, you're going to say to me, you've got to read it all in the round, and I absolutely, of course you are. I absolutely accept
Yeah,
that.
I understand the point. The assessment is not based upon GMI, it's based upon Cérélia, and Cérélia is what's being referred to in 189 and 192.
And I'm challenging the conclusion or the summary of the Cérélia evidence as being mixed.
Okay.
So you have 5 showing Bells is considered a competitive threat. You have the one document which is said to show the opposite, and I'd like to show you that document. It's in what's called the Rationality Core Bundle, the RCB, at tab 6.
Without you to pick you up again,
I know.
the documents speak of Cérelia's view of Bells as a competitor. The mixed comment is as to whether they're a strong or a weak competitor. That's the context.
But if that's the case, then none of the documents then are referring to strength as such as an assessment. So what you have is 5 documents saying, yes, we recognise Bells as a competitor, and you see the statement set out. And I'm going to show you that 9.190, the actual document, doesn't go to the strength in any event. So I understand the language, but I'm not sure much turns on it. I'm not sure the drafting is putting much weight on it.
I mean, speaking for myself, picking up my Lord's point, I would regard 9189A and B as both really going to the point about whether or not a point about the evidence being mixed. We're saying they might be more dangerous than England going forward, not saying they would be. And likewise, one to watch, which is a sort of, might or might not come to something, might not amount to a row of beans at the end of the day.
My lord, I'm
I'm not
not.
saying they are currently a serious threat.
No.
And therefore they are a strong constraint. So seems to me that all goes into the mix as to the strength of the constraint. Anyway, so you're going to show us the document.
And so, my lord, what I wanted to say in response to that was, I'm taking the final report at face value, if you like, because if you go back to 9.189 of the FR, where we just were, you see how the CMA presented this evidence. It said, internal documents indicate that Cérélia has been concerned by Bells as a competitor. So I take that at face value.
Well, I don't think you can sort of dice up 19189 and 190 in that way, because 9192 is really dealing with a thing in the round, isn't it?
No, I understand.
The totality of the material.
So you're looking at the 5 A, B, C, D, E, which certainly show that Cérélia considered Bells as a competitor, and you'll see the comments. I've got to be careful because they're shaded. But for example, C is in stronger terms.
Yeah.
And the way it's presented in the FR is you've got 9.189 internal documents indicate Cérélia has been concerned by Bells as a competitor, and then 9.190 on the other hand, and then the reference to the internal document. So the CMA seems to accept 9.189 is showing Bells is considered as a material competitor, put whatever adjective you want. And then 9.190 is supposed to be the one that detracts from that. And that's the document I want to show you. And it's a series of internal Cérélia emails, the whole thing is confidential. It's marked at the top. So I'm just going to invite you to read
Which
certain
tab?
emails. It's at tab 6 of the RCB.
You want us to read from the bottom up?
What can I read? Begin on page 17. And just to put it in context, you'll see there's a reference to, and in the middle email, I don't know even I can say the names, there's an individual at Morrison's, and you'll see his name. And then if you read the email above, this is from the Cérélia.
Sorry, which page are you on?
So I'm on page 17, which is the second page of the tab. I'm looking at the email in the middle of that page just to tell you who that individual is. You see he works for a retailer. And then you'll see the email at the top of the page. Someone at Cérélia has had a conversation with the individual from the retailer. And then if you can then read it, you'll see the story. And the FR relies on the statement that's made in the final, i.e. most recent email at the top of the page. That's on the other hand, and then it cites that. And you'll have my point already. That statement in an internal Cérélia document is clearly a statement made as part of a negotiating gambit. You see that quite clearly from that thread of emails. And it was not a considered internal view of the threat from Bells. It was go and say to the retailer the following.
Well, the top email on page 16 from the person identified there, who's presumably part of Cérélia,
That's right.
expresses considerable scepticism as to whether Bells are a realistic challenge at all. I mean, if I looked at that email in isolation, I'd say that the findings that were made at 9189 to 9192 were extremely generous to your client, frankly, for present purposes.
Well, I present the evidence. And
They'd be entitled to say, senior management, whatever it was being said by the junior management, presumably Mr. PB is a junior manager, but this gentleman who's presumably in Europe somewhere, yes, he is in the Netherlands, identified as in the Netherlands, didn't think much of any of that.
And my point is, if you read the second sentence, there's the name, and then what you could do is write him an email along the lines of.
Yeah.
Yeah.
This is not in a management account, for example.
Okay, but look at the penultimate paragraph, which is not part of the email, obviously. It's what they actually think.
Yeah.
Which is, I mean, I don't
We
understand.
can't read it out, yes.
I can read it out. I mean,
We can't, no.
No, we can't.
The
And
whole
I
thing's
don't
confidential.
myself understand why we can't read that out, because it doesn't seem to me to contain any sort of confidential information at all. But it's blindingly obvious that they don't think much about Bells at all.
No.
My lords, you have there.
The comment in the last sentence rather suggests what they mean, they think about Bells.
And they think that the retailer in question is simply using this Bells threat, as it were, itself as a lever, which the gentleman who wrote this email is not convinced about at all.
Well, you have my submission,
Yeah.
which is
Okay.
this
Got
is
that point.
a negotiating gambit and not a considered internal view, and that's the submission.
But the paragraph that I was drawing your attention to is not part of a negotiating gambit. The penultimate sentence, starting "we could," I think I'm that to again make sure I identify it correctly.
I think that's probably right.
Is not part of a negotiating gambit. That's the internal assessment of bells.
That's right, but it's not inconsistent with bells being a competitive constraint. It's just a degree of confidence on the part of Cérélia about how they would meet
When
up.
the CMA says the strength of bells as a competitor is mixed, I think would it not be fair to describe that as a pretty
Classic.
that's pretty down on bells as a competitor.
I understand. It's not, in fact, what's put in paragraph 9.190 of the FR.
No, but you have told us we have to read it.
I understand, and I'm not going to resolve from that. So that's the point about Cérelia's views. Then the second point relates to the retailer's views. And if we can go back to the core bundle for this, please. Paragraph 9.192. It's page 357. And it was the second sentence of 9.192. Evidence from retailers except the two names suggests that Bells is not currently perceived as a strong alternative supplier. And our submission that is an inaccurate statement on the evidence. And the details of the retailer's responses are set out at paragraphs 9.184 to 9.187 of this final report. So that's page 354 of the bundle, internal number 189.
Sorry, give me the paragraphs again.
So we're going to begin at paragraph 9.184.
Can I just ask you about the second sentence of 192? There's two retailers referred to.
Yes.
The first retailer did enter a transaction in middle of 2022. Does that mean that the analysis we're referring to there must be post that transaction? That second retailer, it must only be the second retailer we're concerned about, because the first retailer is now subsumed in a contract.
Well, in a sense, I'm taking the two retailers' names are in my bag, if you see what I mean, because
If you read 9.187, that bears that out, doesn't it?
That's right. So what I was going to say is, in relation to Lord Justice Green's question, that retailer he's just referred to is at 9.185. So that's evidence which is in my favour. Bells is a material competitor. And then the second one that's named.
I'm sorry, I think my point is,
Oh, I'm so
it
sorry.
goes back to the CMA's analysis that they assume a transaction, namely the first retailer, and then the question is whether there would be, Bells would have the capacity to take on another
That's right.
person post number one retailer.
That's right. So what we're looking at the moment.
Therefore, that can only be someone like the second retailer referred to.
What we're looking at the moment is retailers' perceptions of bells as a constraint in the market. We're going to come to market shares, which is a sort of different point, and that's particularly where the potential point is going to come in. What we're looking at the moment on the basis of the FR is what retailers have said about bells in their evidence. My point is that the two named do see bells as a constraint in the market. And the first one is 9.185 and the second one is 9.187. So if you're looking at the ledger and the evidence, those two are on my side of the ledger. And there are 5 retailers that are named in this section on the evidence. The third one is at 9.184. If I could ask you to read that, please.
Yep.
So you see that that retailer did mention bells as being one of the main suppliers of PL products.
So then stopped.
That's right. And why did it, what happened, why did it stop? And it's nothing to do with Bell's attractiveness of its offer, ability to compete. If you go to page 351 of this bundle, paragraph 9.173, internal 186. You'll see the reason why supply from Bell's stopped. So that retailer thought that Bell's was a main supplier. You'll see the reason it was dropped. And a strong supplier, such as Bell's, such as recognised by Bell's, can choose to cease supplying a particular retailer. It doesn't mean that they cease to be a constraint in the market.
Just looking at the reasons given in 173, what inference does one draw about the competitiveness of the Bell's offering in the light of those reasons? In other words, what does one infer from those reasons about its ability to pose a constraint in the future?
I don't,
I
well,
have to be careful what
we
I
do
say.
have to be really careful, I know.
You're saying it's actually all to do with the retailer, as well.
Well, I'm saying it's to do with the supplier's choice, because, how do I say?
But that tells you something
Yes,
about what.
Well, not necessarily, because it doesn't necessarily mean, there's a difference between won't and can't.
Yeah, you're saying it's the retailer who basically didn't. I understand why I can't say it, but especially if you don't identify the retailer. But you're saying the problem is at the retailer's end. It doesn't say anything about whether Bell's was capable of supplying.
Correct. To meet Lord Justice Green's
Yes,
point.
that's
right.
That's
Yes.
what you're saying.
Okay, so let's put in the hypothetical. Assume a retailer says to a supplier, I just don't think, in terms of volumes or price, we want to continue with you. Doesn't that lead to an inference that that supplier is limited capability?
No, because if you look at Bell's and go to the shading.
Yeah.
So you've got the sense, however, it stopped supplying PL products to these retailers in September 2022.
Yeah.
You get as, etc. to the end of that line, but then and that's Bell's,
Yeah.
and then you read the rest of the lines. So that is not based on a capacity constraint.
Yeah, you're saying Bell's basically said to the retailer, look, it's not worth us supplying you because you just don't order enough from us.
Bigger fish that we might be able to fry.
We Bell's, don't want to waste our time with you. It's all a problem with the retailer.
That's right.
That's the correct reading that you say. So it says nothing about whether Bell's, in fact, Bell's have got loads of capacity and they want to go and use it with somebody more worthwhile.
That's what the final shaded words suggest.
I'm not certain it's as simple as that. You can have physical capacity, it just may not be commercial to use it in one particular direction.
Just premised on them
say
having
that
capacity.
what they were proposing to do was to go off and supply DTB product elsewhere. It's talking about this is going to be completely impossible, frankly. Not being able to debate with council what's said because it's in grey shading. I mean, they're talking about the lines they're talking about. I hope I'm allowed to use that word. Is not DTB, but the other stuff they made. I mean, Bell's is a Scottish pie manufacturer, basically. Even I know that.
You can't say
as a
it.
Sassenach.
Can't
But,
say it, can't say it apparently because that's grey in the previous paragraph.
so it's not talking about dough to bake at all. And the idea that in the light of 9.173, you could begin to justify saying that retailer, that Bell's was a strong alternative supplier. It's just, well.
Malak, can we go back to
I understand the point you say. Well, this is all coming from the retailer rather than Bell's itself, but the impact of it is still the same.
Lord, I've got a different point as well as that one, which is if you go back to 9.184, you look at what the retailer actually said. It mentioned Bell's as being one of the main suppliers of PL products. That's the bit I'm relying on. It's the CMA that's relying on the stopping in supply. It's the final report that is relying on that bit. The only bit I need is that retailer thought that Bell's It was one of the main suppliers of PL
So,
products.
I mean, your argument is that the paragraph we've just been looking at that created so much sort of heat actually shouldn't be regarded as a qualification in the second sentence of 9184 to the first sentence of 9184.
Correct. And then I say I've now...
Perhaps you say it doesn't matter what 173 says. The boldness of what is said in the subsequent paragraphs really just stands. I mean, if it takes the view that notwithstanding 173 it is, quotes, one of the main, then that's the headline.
That's the headline. You can say that's the headline and that's enough, or you can say that's the headline and the efforts by the CMA and the FR to undermine the headline don't go anywhere.
Because they retain the headline.
Yes. If you retain the headline, then I've got 3 retailers out of 5 in my basket. I've got the 2 named in 9.192 and I've got this one. 3 retailers think that...
I mean, the reality is I've just looked at the document, the minute of the telephone discussion with the managing director of Bell's, page 194 of the rationality document. I mean, never mind what the retailer was saying, Bell's was making the point that there was a very small amount of PL product for those 2 retailers, and a very small amount of revenue, so they gave notice to stop manufacturing.
That's right.
So that's never mind what the retailer said, the totality of the evidence was that it wasn't a strong alternative supply.
But in that context, it is and can be. If you're a strong supplier, you might choose not to service contracts that are just actually too small for you to worry about. I mean, that's the opposite. If you're dropping suppliers or dropping retailers, sorry, because it's not worth the money to you, that suggests the opposite, that actually what you're looking for are better opportunities and you're not going to waste your time on the small fry. So my submission, I don't quibble absolutely with what Roger said about the reason, but my submission is that shows the opposite. If you're a company that's scrabbling for business, you don't turn away business from your door.
Okay. Yeah, so your point is in 9192, second sentence, it says evidence from retailers except suggests Bell's is not currently perceived as a strong alternative supplier. You're saying in relation to this retailer we've just been looking at, that's not what it says.
That's right. I want to add that into the later on my side.
What about the other retailers?
Yeah, I'm going to come to that. So if we next go to 9.186, and if I can ask you to read that, please. And it's just down to footnote 679. And then you'll see footnote 679 is a note of a call with that retailer on page 6.
Sorry, where are we?
So we're on page 355, paragraph 9.186, and it's the first sentence down to footnote 679, which is dealing with the 4th retailer, let's call them.
Yeah.
And footnote 679 you'll see is a reference to a note of a call with that retailer at page 6.
Yeah.
And that call, you'll see the date is given. It's shaded for some reason again. And that date is before Bell's won its new major contract. And if you want to cross-reference that of the final report, which is on page 352. I don't think that's going to be controversial. So a call took place with this retailer before Bell's won.
Well, okay, but when Bell wins its major contract with another retailer, in a sense, its ability to have the capacity to do business with that retailer that we're just looking at is reduced.
But if you look at what the 4th retailer said, it was asked before Bell's had done any business. So when Bell's was just the humble Scottish pie merchant, this supermarket was asked and said, no, we don't think Bell's is a player.
Look, I mean,
The point,
can we see that? I mean, where's that note?
I'm going to take you to the notes. I'm sorry, I was just trying to address your question before I went to it, but I'll take you to the notes. And the point I wanted to make on this was not in the detail, it was simply that a view expressed by a retailer about Bell's capacity was overtaken by events because this retailer said, we don't think they've got any capacity. Bell's then wins a major contract and the fourth retailer is not asked, oh, given what has happened in the market, what do you think about Bell's now? That's the point.
So the facts prove them wrong.
That's right. Or at least prove this view that was expressed early
the
on.
time.
There's no criticism of the retailer.
No.
It's just that things moved on and they weren't revisited. So if I put it this way, if I'm
Well, is that actually right? What date is 67? What date's the document at 679? 28th of November 2022.
it is.
The retailer to whom the retailer who awarded the contract gave a response to the CMA before then.
That's
before
right.
November 22, in which it said that Bell's would be having a contract with them from January 2023.
But that's not necessarily in the public domain.
What does that mean?
Well, we're looking at two different retailers. One enters into a contract with Bell's, and that demonstrates that Bell's is actually a serious player in the market. What we're looking at the moment is a different retailer who is asked at a date before Bell's starts supplying its major contractor, what do you think of Bell's? And the answer that's given is, well, they're just not a player in the market. And events clearly showed that to be wrong.
Would it be fair to take that view as it stood? And you pointed out that with the benefit of hindsight, the doubts which that retailer had proved not to be true. But is it open to the CMA to then say, okay, well, we'll analyse the position in the light of the transaction which did occur?
Yeah, absolutely.
And then
Of
ask
course it is.
the hopscotch question, what happens after that
Of course it
transaction?
is, which is the market share point that I'm going to.
Which is the market share.
Absolutely.
but
I'm
it
just
doesn't-
breaking down
Yes.
the report itself, which is based on.
But
it's
if
a real-
the CMA hadn't done that next step, your criticism might have been sharper. But because it did, does it not rather take the sting out of the first sentence of
That's
9186?
That's why I made the point at the start of this section, which is you have to look at everything in the round. And I might not have a knockout blow on each one of these, but at the end of the day, you hear my submissions, you sit back and you come to conclusion, was this a view a reasonable authority could take?
But can I also, I mean, the contract we're talking about that Bell's got was for puff pastry. Sorry, can I use those words?
I'm in the CMA's hands on confidentiality.
Okay,
My hands
so
are bound as well.
Can I say that the contract appears to be for puff pastry, whereas the note we're looking at the moment, in relation to this other retailer, is a I probably can't even say this either.
I understand what you're saying,
A
yes.
full own brand offer. Are they really talking about the same thing?
Well, the question is, how much value can you put on the comment in 9.186 when that comment is made before a material market development thereafter?
But your point is, look, here's this fourth retailer who thinks that Bell's are just not a player.
That's right.
I think is the way you put it. They're wrong because look, subsequently Bell's was awarded this puff pastry contract. And I'm just sort of
No, I
questioning
understand
that these two are different because the fourth retailer was saying Bell's couldn't do a full own brand offer. We don't think.
Mhm.
Why is that rendered wrong as a view, because Bells have got a puff pastry contract with another retailer.
If the CMA had gone back to this retailer after the Bells contract became public, and said, what do you think of Bells now?
They're great at puff pastry.
Well, or they might say, oh, that's very interesting, they've won a major contract, or we'll be interested in speaking to them. We just don't know. My point is, I'm not trying to speculate about what this retailer might have said. I'm just making the point that the evidence, which is relied upon in the FR, was overtaken by events, and that's the point.
Puff pastry is a small element of the DTB.
It's an
market,
important
or is it?
element.
It's an important element,
Yes.
okay, but it's not the only element. There are.
I understand the point you're
I mean,
making, Lord,
Can we talk about? I mean, the DTB concept embraces puff pastry and other
That's
dairy products. So the fact that Bells has awarded a puff pastry contract doesn't cast much doubt upon whether it can still operate in the industry as a competitive restriction.
It might have
in
changed.
relation to other aspects of the DTB market.
Bells had never been seen in the market. It was a Scottish pie maker, as the Chancellor said. You've seen the figures, the market share
Yeah,
figures. And then it won this contract, and suddenly it's on the market. So the other retailers we've looked at were all right about, in their views of Bells. And the point I'm making is, in the FR, the views of this fourth retailer are based on something that was overtaken by events. And I understand the point about puff pastry and food value, but what clearly happened is that Bells became a material player in the DTB market. You see that in table 9.1.
So your point boils down to just this, that the observation in the first sentence of 186 is correct at a point in time. In the light of what the CMA knew had happened, it needed to be reassessed.
Yes.
Whether it was puff pastry or the full DTB offering, there was a requirement for reassessment before it could be treated as having probative value.
Well, it's either, I'm not saying that they had to go and do it, because of course they have a discretion about how to investigate, but what I'm saying is they can't put all the weight on that statement when they know it's been overtaken by events. And if they wanted to rely on that...
It's identified in
Sorry.
9186 in the first sentence. Is the retailer who'd said it's elsewhere in the report, I know, and I looked at the underlying document, who'd said that that retailer only used Bells in Scotland in a limited number of stores, and only for puff pastry. And it also said, we don't think Bells is worse the effect. Given our current pastry dough product needs, as they put it, we want to use one supplier, all eggs in one basket. And we don't want to have to be dividing up. And this supplier, Bells, is just not big enough. I mean, that's effectively what they were saying. And the fact that another retailer may have awarded Bells a contract doesn't impugn that as an analysis by the other major retailer.
My lord, what we're looking at are retailers' perception of Bells as a market, as a strength.
That's
in
a pretty clear
Can I
bit
finish?
of evidence from March 2022, tab 12 of the nationality bundle.
The point I want to make was, in order to be a material player in the market, you don't have to contract with every retailer. You might have a perception of Bells as not being a player in the market up until 2022, but then it wins a major contract. And the fact it doesn't win a major contract with every retailer doesn't mean that the other retailers, when they become aware of the contract, won't say, oh, actually, we need to think about Bells again, because look, they have won a major contract. So I think you have got to be, with respect, careful to disentangle, is Bells doing a contract with this particular retailer? And what's actually happening in this bit of the FR, which is the CMA is relying on retailers' views of whether Bells is a material player in the market.
Right.
It's a perception point at the moment. It's not, would you do a contract with them? Have you done a contract with them?
Right. Okay.
And then, so we've done 4 retailers, And the final one, again back to paragraph 9.186, told us that it had previously considered bells as part of an exercise to consider the competitiveness of its current offering from Cérélia. It concluded that from a cost-based point of view and a quality point of view, Cérélia provided superior products. And we say what is important here is that this retailer had considered bells as a potential alternative supplier. But on this instance, it preferred Cérélia. But in terms of perception, that retailer had thought that bells was a potential player in the market. It just happened to lose out on that particular contract. But it's a sort of facet to the point I just made to the Chancellor. You don't have to win every contract to be a player in the market. But you'd expect a player in the market to be considered when retailers are entering into contracts. And that's what happened with this retailer.
Sorry, I'm not sure I'm following that. That retailer had entered into some preliminary discussions with Bells,
Yes.
but decided that in fact Bakerway was superior, and so they went with Bakerway and they didn't continue the discussions with Bells.
They awarded the contract to someone else. Yes.
Why is that? Isn't that what that's accurately reflected in that paragraph 9186 second sentence, isn't it?
The fact that we're dealing with the perception of retailers of who are players in the market, and the fact that you invite or begin discussions with a particular supplier is evidence that you consider them as a material player in the market. Otherwise, you wouldn't waste your time starting the conversation.
Well, no, I mean,
Is
I
it-
think
I'm
when
sorry.
you actually look at the document, at page 242 of the rationality bundle, core bundle, I don't know, if you read the full extract from line 7 down to line 12, can I say it? I mean,
It didn't actually take it any
it
further.
doesn't seem to be marked. If you had the conversations just to understand where we were from a competitive point of view. I mean, it's a very preliminary sort of
So we decided not to further those conversations.
toe in the water. So, you know, it's just trying to understand who they were, really, I suppose, where we were. I mean, it's very tentative, isn't it?
Discussions were had as identifying Bells as a potential supplier. Bells did not succeed in winning the contract. Absolutely.
It wasn't a question of winning a contract. It's just this particular retailer just wanted to see where they were in the market. Didn't take them very long to figure out that.
Well, I think
Not to waste any time with Bells.
I understand it, but I think we've got to be careful not to read too much into or put the gloss on. We had some discussions with Bells to understand where we were from a competitiveness point of view, and then you have the statement that follows.
But well, I mean,
I don't know the details of those
ironically, the
conversations.
last sentence of 9186, which is not shaded, appears to be shaded in page 242 for some bizarre reason. But I mean, that's exactly what it says. It's pretty well word for word. How is that not an accurate recording by the CMA of what was said by this particular retailer?
So I'm not
And what its conclusion was?
I'm not doubting the accuracy. I'm so sorry. I'm just saying that we can't read anything beyond what's said here. There were discussions with Bells.
Didn't go anywhere.
That's right, because Cérélia was seen to be better. But if we're looking at the question of perception, was Bells a potential supplier in the market? My submission as evidence shows that it was, but it didn't win this particular contract.
So what we have is a series of pieces of evidence, which I'm just trying to list them, show that there were interreactions involving Bell on a number of fronts. First of all, extent to which it had any spare capacity at various points in time, its likelihood of it being able to use surplus capacity in the DTB market, the history of contacts between a retailer and Bells, the offerings in the past and whether it was complete or partial, offerings in terms of prices and offerings in terms of quality. So those are the sorts of things that these pieces of evidence go to. And at the end of the day, the CMA has to form a view based upon this scattering of the evidence as to the strength of Bell's competitive constraint. So it's a bit difficult to, and as you rightly point out, some of this is quite partial and it's difficult to draw very accurate inferences from it because it's not complete. But there's a range of different facets of competition which are covered by these different bits of evidence. And the CMA has simply concluded on the back of it that bells constitutes a limited competitive constraint.
That's right. Well, in the FR, as I've said, there are 4 factors, broad factors, and there are then sub-factors absolutely identified. So what I'm trying to do to put some structure on this is I'm taking you to the Cérélia internal documents. What I'm looking at now is the second sentence of paragraph 9.192, which is retailers' perceptions of bells as a supplier. I'm going to go on to market share. But when I'm looking at the perceptions of bells, you've got the 2 that are named in that paragraph, which are in my side of the ledger. You've got the retailer at paragraph 9.184, which I've submitted should be in my side of the ledger. And then you've got the 2 remaining retailers in paragraph 9.186, and I'm not saying they're firmly in my side of the ledger, but I'm saying they're sort of in the middle. They're not saying bells hopeless. And this is just me looking at the perception ground. So you have 3 on my side, 2 which are not inconsistent with my side, and that's the submission. And I was going to move on to deal with market shares, which is my third point on the assessment of bells. And I should put the sort of warning up sign. This is one of the new arguments that we sought permission to raise, and Lord Justice Green has made a ruling on, so I'll address it on the substance.
As you understand, we don't want you to deal with it as an application. We'll hear the merits, and then we will have to decide as a matter of principle how we deal with it in judgment.
So can we go to back to paragraphs 9.193 and 9.193 and 9.194 of the final report? That's page 357. And you'll see that the CMA recognised that bells might be able to meet the PL needs of an additional large retailer. And if bells were to win a contract with an additional large retailer, on that basis it would have, and I'm going to use the bracketed range, bells would have 10 to 20% share of the market, and that would all be PL, whilst the market share of the merged entity, which would be PL and branded, would be 50 to 60%. And you'll see from these paragraphs that what the report does is it compares the bells share of the market with the total combined share of the merged entity, which is Just Roll and Cérélia. So you're comparing the 10 to 20% of bells with the 50 to 60% of branded and PL of the merged entity. That's what the report does. And can we go back to table 9.1, which is at page 288. It's internal page 123.
Sorry, give me the reference again.
So it's the internal page 123. It's above paragraph 9.9.
283, sorry.
123 of the internal numbering paragraph. It's just the top of that page, and it's below paragraph 9.8, which is actually on the preceding page.
Yeah.
So do you have it, my lord? Thank you. So this shows the position in 2023 bells having won one major contract. If it were to win another major contract, then the shaded figure in blue would double.
Yeah.
And the range would go up from 10 to 20%. And if bells were to double its market share in PL, of course, it would have to win it from someone. And it's likely to have won it from Cérélia. So you have to then subtract the relevant uplift on the Bells from the Cérélia figure.
Yeah.
And therefore, on the basis that Bells might win another major contract, the figures would read Just Roll 40 to 50%, Cérélia 10 to 20%, Hengline 10 to 20%, Bells 10 to 20%, another PL 10 to 20%. Those would be the individual ranges on this scenario. Now, importantly, if you're considering only the PL suppliers, then their share of the total DTB market would be Cérélia 10 to 20.
Can I just
Of course.
read in? Can you just repeat what you just said?
Absolutely. So this,
So assume Bells wins another contract.
that's right.
So it goes to 10 to 20%.
That's right, because the figure in blue is doubled,
So you have to take it out of,
the Cérélia figure.
or you take it out of, no, you don't, you take it out of the top two combined.
That's right. These are combined market shares.
Right, so you take it out of the combined market share, which drops the combined market share of the merged parties from somewhere between 60 and 70%.
To 50 to 60%.
56%.
But the point is,
And the point
sorry,
that's made in the report is it's still therefore 4 times
that's right.
as much,
That's right.
which in fact you can with an inaccuracy of about 1%, you can calculate the number in the shaded.
Well, the figures at
Just out of
9193 and 194 are exactly those figures that are shaded, aren't they?
Yeah, that's right, but you can actually figure out what the shaded figures are to within 1% from the unshaded documents, numbers that we've just been talking about.
Well, my hands are tied as well. I'm sorry it's so difficult.
Yeah, you don't have to be a mathematical genius to figure it out. You need just to be able to multiply by 4. Right, okay.
But what I want, so that's absolutely right, as you've described it, that is what is done in the final report. And the point I want to make is, if Bells wins another contract, it's a PL contract, because Bells is a PL supplier.
Yeah.
So the amount that will be lost by the merging entity has to come out of its PL total.
Yep.
And in this table, the PL total is Cérelia's total, because we know that Just Roll is only branded and Cérélia is PL.
Okay, right.
You follow me?
Okay.
Yeah.
So that's why when I say, if you're considering only PL suppliers, you've got Cérélia 10 to 20%, you've got Hengline 10 to 20%, you've got Bells 10 to 20%, and you've got the other PL 10 to 20%. And you immediately see that those market shares are not evidence of market power in the PL channel, because everyone's much for muchness in that PL supply channel. Now remember what the CMA's theory of competition is in this case. The theory of competition is that branded and PL products do not compete directly. The competition is cross-channel insofar as retailers have to make a choice how to allocate their limited shelf space as between branded and PL products. So the ability of the merged entity, which is PL and branded, to wield any market power in respect of its PL products will be constrained to the extent that there is competition between the other or with the other PL suppliers. The merged entity is selling PL products, it is constrained by the other PL suppliers. And the ability of the merged entity to wield market power in respect of its branded products on the CMA's own theory of harm, or theory of competition, will also be constrained by competition between the PL suppliers. And that's because the branded and PL products compete for shelf space. So if the merged entity seeks to raise its prices for branded products, it will lose shelf space to PL suppliers. And so the point is this, that simply comparing the total market share of the merged entity for PL and branded products combined with the PL shares of other suppliers doesn't take account of that aspect of competition. And that aspect of competition is the bedrock of the report. And there is no analysis in the decision of the relative market shares for PL suppliers were Bells to win another major contract. What would the competitive framework look like? And we say that's a material error in the CMA's purported reliance on market shares. Given its own theory of competition, it should have asked itself that question.
Yes, I mean, you're essentially saying that the analysis at 9193 to 9195 is wrong because it doesn't differentiate between the PL and branded channels.
It's not
It just talks about size in the combined market, and you say that's an error.
I say it's not wrong, but it's materially insufficient given the CMA's own theory of competition is based on that cross-channel aspect.
Yeah, what you're saying is that Bells would be a true constraint on the PL operations of the merged entity if Bells were to win another
That's correct.
contract in the market.
That's correct. And it would also be a constraint on the branded products of the merged entity because the branded products compete for shelf space with PL products. Therefore, if the merged entity put up the price of its branded products, it would lose shelf space because of the competitive nature of the PL supply situation. So I'm simply taking the CMA's own theory of competition and I'm holding up their market share assessment against that and saying,
The premise
Is
of
that
this, of course,
sufficient?
is that the Bells would
That's
have
right, I
the
understand.
ability and to get that extra contract, which the evidence suggests is far from clear that Bells actually wanted to do that.
well, if you look at paragraph 9.193 again, I'm just going to base myself in what the CMA concluded from the
Yes,
evidence it had.
But the actual elsewhere, sorry, elsewhere in the report, it's clear that Bell's enthusiasm to take on another contract, which is the foundation for your analysis, I understand, is limited. It's qualified, shall we say?
That's it, I'm happy to accept it's qualified. But the point is at 9.193, we recognise that Bells may be able to meet the PL needs of an additional large retailer. And the whole premise of this part of the report is, assuming it were to win another contract, what would the market shares look like? So I'm simply taking the same premise, assume that Bells were to win another major contract, what would the market shares look like? I'm simply dealing with the
On
reported
this
face value.
new hypothetical contract, a fortiori it no longer has any spare capacity.
That's the fourth point.
How does it then exert constraint? I mean, it's the ability to take on a new contract beyond X that creates this competitive threat you're identifying. It's not the position after it's taken on this new hypothetical contract, is it?
Well, I think it must be both, because the
It
ability...
assumes Bells has almost unlimited capacity.
No, sorry, let me explain. So we've got two stages here, or we've got three. Bells has won a major contract, we know that. Bells may win another major contract, and that's the premise of 9.193. If it does that, it will then have a market share in the PL market, which is in the same range as Cérélia. At that stage, I say that would be clearly a competitive constraint, because when Cérélia is thinking about what to do in pricing, etc., it will have to be aware of that material player in the market. And Cérélia will not know all the details of Bell's capacity by definition. And then you have the third stage, which is Bells has won the second contract, but its capacity at that stage is limited for the reasons we see in the evidence. But Cérélia won't know that, because by definition you don't know what your competitor's position is, so there will be less of a competitive constraint, I accept, in stage 3, but there will still be a competitive constraint.
Can I ask you about the procedural context of this? To what extent was this argument run in front of the CMA? or the CAT?
It wasn't.
No, I understand. Okay. So, a point we do have to grapple with is, however attractive this sounds, if it hasn't been evaluated at first instance by the CMA, it's not in the decision, not put in front of the CAT, is it something that we properly can take into account?
I understand.
Even if we think, that's
Like
delightfully advanced.
However well I've done. No, I'm not upset. I'm not trying to pull the wool over our eyes at all. That's
No,
why
we
we put
understand,
to the
thank you.
supplemental skeleton.
But you say you can make this argument simply on the back of what's here.
That's right.
And it's something that we're as well placed to evaluate as the CAT.
Correct. Because all I'm doing is taking the CMA's own theory of harm, and I'm taking table 9.1 and I'm putting them together. I'm not introducing new facts.
We made a number of assumptions about the facts and the theory of harm. I mean, there is some evidence about the extent to which retailers view competitive constraints. I mean, it could be much, much messier than the very elegant way in which you've described it.
Yeah.
And the CMA haven't, if they haven't grappled with this, we've got we've got two vacuums.
The decision is sort of, for me, I don't want to play off against each other. You have my submission, which is, as not just as Snowden put it, you can do this on the report itself. And I don't, insofar as I need, anything beyond that, I imagine you may say, you just can't have that. But there's the report, take it at face
You
value.
say you don't need to be a specialist tribunal to engage with the argument you're putting forward. It's there on the face of it.
That's right.
It's either right or it's wrong.
That's right. But I completely understand that there has to be fairness to the CMA. I'm not trying to, that's why I'm being completely open about how it's come up.
Okay.
So we then go to the tribunal judgment to see what did happen below. That's core bundle tab 7.
Just before you
Of
do,
course,
I mean,
sorry.
the point I was trying to make is that for the CMA, though, evaluating this evidence, I know you say on the hypothesis that they have themselves made, they didn't follow through in the correct way, but the whole hypothesis is underpinned by a big, I was going to say underpinned by a big question mark, which is that the whole hypothesis upon which this is based is that Bell's would win a contract in a second contract in the market.
Or might win, I think, because potential competition is sufficient.
Okay, might win, but we haven't looked. I mean, it is right, isn't it, that elsewhere in the report it's quite clear that the actual prospect of Bell's wanting to do so in the short term, medium term, is highly qualified.
Well, what you have in relation to Bell's, if you've still got the FR in front of you, is just to look at what the section looks like. It begins at page 351, which is internal 186. And you'll see the heading Bell's, and then the subheading Evidence.
Yeah, it's 183, 9183, which we haven't looked at. That's what I was referring to.
That's right.
Which is a fairly major qualification about whether we actually even get into the hypothesis that you're talking about at the moment, isn't it?
That's, it's potential, I accept that.
So,
And
so when you're evaluating weight, to be given to all these factors to answer the question, is Bell's a strong constraint, or medium-sized constraint, or weak constraint? You have to look at the underpinning of the last point you've been making, surely.
So what you have is, you have that section on the evidence, and that runs to page 357, page 192. And then you have our assessment. And what I've been focusing on are the 4 points that relied on in the assessment.
Yeah, but
And the assessment in relation to this point is, as is set out at 9.193, we recognise that Bell's may be able to meet the appeal needs of an additional large retailer. So what you don't find in the assessment is that sort of reliance on the point that you were raising with me. Now, I completely accept the evidence is there. The CMA could have said it. And the reason why I sort of insist on I'm looking at the assessment is, in our submission, the function of the court below, and indeed this court, is to look at the reasons that were given by the CMA and not to try and come up with its own reasoning.
no.
But you say that qualification that I've been drawing attention to, which is in the 183, is not reflected in the assessment of the CMA at 193. But it is, isn't it? I mean, it says we recognise Bells may be able to meet the PL needs of additional, but they say even if Bells was to win an equivalent size contract again. I mean that's reflecting those substantial doubts earlier in the document.
But
That
it's
comes
also-
back to it in 199, 195, doesn't it? Even if. But can take on a contract equivalent to the size
If I
of
was
what
coming to
they've
this cold and I'm looking at 193 and 195, I'd say, wait a minute, what do you mean even if? Where does that even if come from? You know, I mean, even if is a very odd wording to use unless you've said something before which suggests that actually you think this isn't really, you know, a strong possibility. And the even if comes from 183, doesn't it?
Well, remember that this whole assessment is necessarily hypothetical because we're imagining what the constraints would look like post-merger.
True, but you're saying
so-
this possibility,
That's right.
this hypothesis, is one which was a strong weight in your basket. That
That's
Bells
right.
are an effective competitor in the PL market if
Has the potential to be an effective.
yes. And again, so in evaluating that potential, we've got to look at 183, haven't we?
Well, the CMA has looked at 183, obviously, it's in the report. And you'll see that despite that, what the report doesn't say is, in light of the evidence at 183, Bells is never going to expand any further. It doesn't say that. What it is premised on is the possibility, the potential, you insert your appropriate word, that Bells may expand. And that's the basis upon which the assessment is made. So it's not a finding on the evidence, Bells cannot take on another contract. The whole basis of this is, it might take on another contract, and what would the world look like if it did? But then what you've got, if you, in this assessment is identified, and you have my submissions that 3 of the 4 principal reasons, submissions on the analysis of the market shares. The 4th one is the capacity point, which I don't put a specific challenge to because we've seen the evidence, we've seen the findings. I'm not Don Quixote, I'm not going to charge at windmills. But if there are 4 reasons upon which the assessment is based and you come to the conclusion that 3 of them are flawed, I would submit that you can and should in the round take the view that the assessment was so flawed that it should not stand. And that's the way we put ground one. I was going to take you to the tribunal judgment, core bundle tab 7, page 109, paragraph 168.
Doesn't really deal with the evidence, does it?
I'm sorry.
It doesn't really deal with the
No,
evidence.
that's right.
It's rather broad brush.
That's right.
Could we just ask you one question about the approach of the tribunal to judicial review generally? I mean, it sets out at some length its approach. It starts by citing with approval IBA and Edwards and Bairstow, in which it then says that merger cases are at one end of the review spectrum, and it implies that at the high intensity end of the spectrum. And then it goes on to cite cases in which it suggests that the intensity is exceptionally low because you have to show a manifest absence of justification. Looking at the parties' skeletons, parties seem to prefer the IBA formulation. Would that be fair? That the task of the tribunal is properly to grapple with the facts and then to work out what the scope of the margin of appreciation of the CMA is. But there's no short-circuiting of the work the tribunal should do, which is grapple with the evidence.
I mean, that's certainly right. And that, of course, is reflected in the European practice as well. I know we're no longer a member, but the reason why I raise it is because that was necessary for human rights reasons. Here it's not a fine, but it's a interference with property. So again, you have that necessity. So absolutely, we would adopt that.
So where are we going? Sorry.
So we're in the judgment at paragraphs 168 to 169. And this is where the tribunal sets out its assessment in relation to bells. Again, I just ask you to remind yourself of 168 to 169.
Yep.
So you'll see from the first half of paragraph 168, apparently the tribunal didn't necessarily consider that the CMA's conclusions on bells were clearly right, but except that is not the test. The test is irrationality. But when one comes to that assessment, the tribunal did dismiss Cérelia's arguments in very short terms. First of all, in the second half of paragraph 168, the tribunal assessed and rejected Cérelia's arguments on Bell's capacity. But as I've shown you, the CMA's reasoning in the final report is based on 4 reasons. And the tribunal didn't address Cérelia's other arguments in relation to the views of Cérélia as to Bell's capacity to compete, the views of retailers, and I accept that my market share point, there was a market share point below, but I accept the way I put it now is a new one. But the tribunal did not grapple with all of the arguments below, it simply focused on the capacity point. And then the second reason given by the tribunal is in paragraph 169, which is with all due respect to the tribunal, a quite surprising one, where it said, in assessing Bell's submissions to the CMA, it should be borne in mind that rival suppliers such as Bell's would stand to gain from any relaxation in competition in the market in which they compete. And it's difficult to know where to start pulling that apart. I mean, first of all, it's an entirely new point that wasn't relied upon by the CMA in the FR or at the hearing before the tribunal. But again, with all due respect, it's a bad point. The whole premise of the final report is that the merger would create a stronger competitor for Bell's, not a weaker one. And it's far from clear that a company such as Bell's would welcome the creation of a potentially stronger competitor in the market. So the premise upon which the tribunal says, well, we're not going to attach too much weight to the Bell's evidence, just doesn't make sense from a competition perspective.
It's your criticism, on the one hand, I mean, a body like the tribunal is a specialist body. It's entitled to exercise its own forensic intuition and decide, look at motivation. So is your criticism that they looked at motivation or that they got it the wrong way round? Because it's more likely you would say that this is a point in your favour that a third party would exaggerate the anti-competitive effect because they want to see the merger prohibited rather than underplay it because they can somehow benefit from some oligopolistic price leadership.
It's certainly the second one, and that's that, I think, with respect, is the main point.
Yeah.
It's also the first one because it was pulled out of the hat. It wasn't an argument the CMA was making. But the pulling out of the hat was probably just then reflects and bleeds into the second point. Because it wasn't tested, it was in any event a bad point. If it's a bad point, it doesn't matter if it's a new point or not, it's a bad point.
Have you said all you were going to say about 168? Because if not, if you have, then
Yes,
I'm going to
so-
go right. So isn't 168? I mean, I had to read this a number of times, but isn't it effectively putting? It's the point I was putting to you a little earlier, isn't it? Isn't that the point that it's making here? In the third sentence, it was open for the CMA to have done more to explore whether any given loss of Cérelia's PL volume to a rival PL supplier would have credible have been sufficient to provide an effective competitive constraint on Cérelia's pricing of PL products, thereby placing less emphasis on simple market share considerations. Isn't that I mean, it's been polite to the CMA, but isn't it actually making the point you were making that rather than just taking the combined joint market share, the CMA should have focused on the PL line alone, because if you focus on the PL line alone, if Cérélia loses another contract to Bells in the PL line, there would be effective competitive constraint on Cérelia's pricing of PL products.
It may well be
So
that
I think that was possibly your new point, wasn't it? Anyway,
it is my new point. I have to be open. My understanding, having obviously asked the question and looked at the materials myself, is the point wasn't put that way below, but it may well be the tribunal saw the point, and that's what it's referring to.
That's what I thought it was
Indeed.
referring to. But then they go on to say, in essence, in the remainder of the paragraph, but actually, the idea that Bells has this spare capacity to do another big contract is contentious, because as they say at the end, the CMA could have concluded that Bell's spare capacity was only a limited competitive constraint for the reasons set out. And they explained that Bells had left its options open and naturally would want to see how its new contract would develop before taking a decision. That's the 9183
Yes.
point. So I read that paragraph as countering your argument about the failure to look at PL with, yes, but it's sort of even if Bells were going to go into the second thing. So why is that?
Because the argument I made wasn't put below. I mean, I'd love to be able to say, oh, absolutely, I'm wrong.
Well, no, but
It
you may
wasn't
be
that way.
right.
It wasn't made that way.
But even if you make the argument,
I know you're coming next year.
Even if you make the argument, why hasn't the cat given the answer to it? Why are they wrong to say that's
Because of the
CMA
way
would
it's
do it?
treated in the final report itself, which, I mean, we've been through paragraph 9.193 and 1.194,
183, 193.
where the whole of the CMA's analysis is not saying, because of the evidence on capacity, we conclude that Bells will not win a second big contract. The whole premise of 9193, 914 is engaging in the fact that it might potentially win another contract.
But the doubt is expressed in the words even if.
Exactly, but that could just be the doubt of a hypothetical rather than the basis of the evidence.
Okay.
But that's what I wanted to say on ground one, unless there are any other questions. Ground two, you'd be glad to hear, is shorter, and we don't need our waders to go into the weeds so much. Ground two relates to hanged line, and this is one we have asked for permission to amend, and you'll see the amended form of the ground is in core bundle tab 3.1, page 36.2. It's internal page 2 of that document. And here, the shading is not confidentiality, you'll be relieved here. The shading is the bit we're asking for permission to introduce as an amendment.
Yeah.
And it's an allegation of failure to comply with the duty to consult. So just to give you a bit of background to Hengline, if we can go to the final report, which is in tab 10 of this core bundle, page 366, paragraph 9.226, it's internal numbering 201. If I can ask you to read, please, paragraphs 9.226 to 9.230 when you get the background to Hengline. 9.226 to 9.230.
Yeah.
Then it's common ground that the CMA is under a duty to consult. Indeed, one finds that in the statute, in the Enterprise Act. If you could pick up Authorities Bundle tab 1 at page 39. Section 104 of the Enterprise Act. And if I can ask you to read subsections 1 to 4, please. So, common ground that there is a duty to consult. And then the relevant principles in relation to the duty to consult are summarised in the Tribunal's judgment for Bundle tab 7, page 72, paragraph 63. And again, if I could ask you to read, please, paragraph 63 to remind yourself. I'll pick up 2 points afterwards. The 2 particular points I'd like to draw to your attention are paragraph 63 sub 3. Fairness requires that the gist of the proposed decision be disclosed by the CMA. That's a familiar legal concept. And 63 sub 5 is important. The relevant question is not whether the applicant would have had something material to say in relation to information it did not see, but whether on the basis of the information that it did see, the applicant was in a position properly to formulate its response to issues likely to adversely affect it. So that's, I think, uncontroversial in terms of the legal principles and the duty to consult. And our submission is that prior to the publication of the final report, we were not given an adequate gist of the CMA's intention to find that Hengline offered only a limited competitive constraint on the merging parties. In the provisional findings we find in the RCB at tab 1.
Again, this was not the point taken in account.
The duty to consult point wasn't taken, that's right, I'm sorry, I should have put the warnings.
Can I just ask you about, and this is probably stepping beyond the bounds of what I should say about 63.5, because I was in the case and I lost this point.
Oh dear.
I always found it slightly odd, the proposition that if an applicant could have said something material about something which is withheld, in other words, material i.e. relevant, it doesn't matter if the gist enables them to say something relevant. If something's withheld about which an applicant could say something which was important, relevant, and its hypothesis exculpatory, it's slightly odd, isn't it, that it's okay that it's withheld.
Sorry,
So, page 30 of the judgment.
I understand.
Unless it is that the gist adequately covers that which is withheld.
You may be right. It's good to see you're still not bitter. I'm not sure I need to go into that for these purposes because
I think it
if
is.
the finding-
I think it is an attempt to past history, isn't it?
if the test was an adequate gist provided in relation to the issues in which the CMA proposed to take a decision adverse to the applicant's interest, that's.
It
We'll
must be
see where we
possible.
go, but for the moment, that's sufficient for my purposes.
But adequate means sufficient to enable you to put your full case.
Yeah.
That's right.
In which case, if something's withheld, it's not relevant.
It's not an adequate gist.
It's not an adequate. If something's withheld, which would have been relevant to the gist, then it's not an adequate gist.
That's right.
That's the point.
But I mean, I'm just going to show you. It's quite a high level point. It's just the way it was put.
Yep.
I feel bad now for not preparing overturning Eurotunnel my submissions.
Don't worry.
So yes, we want to go to the provisional findings. They are in the RCB tab 1. I want to pick it up at paragraph 9.181, which is internal page 148.
Sorry, which bundle are we in?
So I'm in the RCB, the rationality.
Rationality bundle.
Tab 1, page 2.
Page 2.
Page 2, yes, so
Yeah.
paragraph 9.181.
Yeah.
And this is obviously the draft report, if you like, at the early stage that is then finalised. But parties have a chance to comment on this final report. So you'll see the format is the same as the final report. You see the heading hangline, you see the reference to the evidence, and then you'll see on page 6, above paragraph 9.197, our assessment. And the assessment is set out 9.197, 9.198, but it's 9.199 that I want to draw to your attention. Overall, we consider a hangline to represent a material constraint on the parties, particularly in relation to competition for smaller supply contracts of the sort it has now. However, we believe the constraint exerted by hangline is likely to be weaker when it comes to competition to supply large retailers for the reasons described immediately above. And I ask the rhetorical question, what is the gist being communicated here? In our submission, the gist being communicated is that hangline is a material constraint on the parties. And that's the first line of para 199. Albeit, they say the constraint is greater for small supply contracts than for large retailers. But the important point is that hangline is a material constraint. And then there are other paragraphs that relate to this in the provisional findings. If you go to page 7.2, it's paragraph 9.220 sub B.
Sorry,
Right.
where do we find this?
So if you start at page 7.1, still in the, do you not have it? There were some pages that the CMA asked to add, maybe they've not found their way in, sorry.
No, they've been left on our dash, but they haven't been put in the bundle.
Sorry. So I've just been trying to look at the two side by side, so I haven't kept up with the page numbering. Just go back.
Do you want to go back to the
Well,
previous point? Or?
I've just been reading 9.199.
That's right, and we're moving on to paragraph 9.220.
9.199.
But you don't want us to compare 9.199 with the final report? That-
No,
I'm going to
9.6.
absolutely do, yes, that's the whole
Okay,
premise. But
right. Sorry. Okay, so we need to go to
9.220 on page 7.1, which
which hasn't been added to
it's
the
been added to the bundle, that's right.
not to the electronic one. Right. Bear with me.
Do you need hard copies? Have you got a hard copy? Should be on the
I've got a hard copy. No, I think I put the hard copy in, but I put the hard copy in, but it hasn't updated the electronic.
So you'll see paragraph 9.220, CMA's provisional conclusion on the degree of constraint for PL suppliers. And it's B, PL suppliers based in the EEA offer some competitive constraint. In particular, while the competition that Hengline is likely to offer in relation to its current retail customers is material, it will be less likely to constrain the parties when it comes to contracts to supply large retailers. And I appreciate that's not in exactly the same terms as the sentence we've just looked, but the gist again we would say is certainly there is a material constraint. And we'll see when we come
to the large retailers, are we referring to, as it were, the retailers in the table 5.5, the list of the big supermarkets basically?
I think that's right.
And they are about, was it 80+% of the total? 80, I think.
I can't remember the figure.
About 80%.
I think it's over 80.
And then 9.261 sub B, again the reference to material constraint, mainly in case of its current retail customers, but weaker competitive constraint in case of the large retailers.
Yeah.
So we say the gist here is that there was a material constraint for the purposes of the CMA's assessment. And then there was a consultation on additional evidence. This is in this bundle at tab 52. And this was sent to the merging parties on the 19th of December.
That tab again, I'm sorry, Mr.
No problem, it's tab 52. So the CMA sent this document to the merging parties on the 19th of December 2022. And the purpose of this consultation was to give the merging parties an opportunity to comment on further evidence that had been gathered after the adoption of the provisional findings inter alia in relation to the competition constraint imposed by existing competitors. And that includes Hengline. And you see that in paragraph 4. And then paragraph 21. See, it's slightly odd because the name of the company we're considering at the moment is shaded. But you can read paragraph 21. The important sentence is the second one. So this is put out specifically to allow or to permit consultation with the merging parties in relation to further evidence since the PFs. And what is said is we continue to consider X to represent a material constraint on the parties, particularly in relation to competition for smaller supply contracts. So again, what is the gist that is being communicated here? The gist is that Hengline is a material constraint on the merging parties. There's then a distinction made between smaller supply contracts and larger ones, but it's stated in terms it is a material constraint.
But only in relation to the smaller supply contracts.
Well, it says,
which is where it was coming into it was still coming into the UK market in limited areas, but it goes on to say in each of these documents, including the paragraph you know now again takes us to 9246 in the final report, the constraint exerted by Hengline is likely to be weaker when it comes to competition to supply large retailers.
that's right.
So in the bulk of what we're focusing on, it's a much weaker constraint. And also it's limited to PL supply.
But my lord,
It doesn't supply doesn't supply branded product.
But the point is that even with the distinction between smaller supply contracts and larger retailers, what is said in both the PFs and the specific consultation document is that we continue to consider Hengline to represent a material constraint on the parties. So I appreciate it is then described, but the punchline, if you like, is that overall, looking at the position in relation to smaller supply contracts and larger retailers, it is a material constraint. That is what is being put to the merging parties in this document. And you're absolutely right that we're now going to go to the final report. So we're back into core bundle at tab 10. It's paragraph 9.246, as you anticipated. And what is said in the final report, the finding is, the CMA does not consider this evidence alters its assessment that Hengline offers only a limited competitive constraint on the parties for a range of reasons. And then you go on and see the nuance. But there is clearly a 180-degree difference between saying, even given the situation in relation to small suppliers and large small customers and large customers, Hengline is a material constraint. 2, taking account of exactly the same facts, it is a limited constraint. And that point, i.e. taken on account of all the evidence and the nuances, that the CMA was going to find that Hengline was a limited competitive constraint, wasn't put to Cérélia. That's absolutely a material gist that should have been put. And it's not enough just to put a basket of evidence, because it's obviously fundamental to how a party will respond to a consultation. If you understand from the basket of evidence the CMA thinks it is a material constraint, that's what you want. But if the CMA had said it's a limited constraint, you realise there's a problem. This is
What would you have said that would have been
fundamentally
different?
important. I'm sorry?
What would the parties have said that would have been different? If not, one of the critical issues was the nature and extent of the constraint posed by Hengline. It's common throughout that they were a constraint.
Mm-hmm.
What's new now is that it's limited, and the word limited might or might not be an apt description of what's said in the provisional findings, but since all along the extent to which Hengline was a constraint was a key issue, what new evidence would have been put forward or advanced had they known that the label attaching to this basket of evidence was limited?
Well, that's why I took you to paragraph 63 sub 5. I was thinking about it for a different reason. What the legal test is has the adequate gist been put? What you're not looking at is what might the party have done. And that's very clear. That's the summary of law, paragraph 635 of the tribunal judgment, the summary of your time. So you're only asking yourself the question, was the adequate gist put? Yeah, you have my simple point.
Okay. Assume you're right. Is your submission that since this is a judicial review, any materiality analysis which might follow therefrom it disappears because it's a procedural point about consultation?
I think it's because it would be very unfair to Cérélia to say in that context, what would you have done? It should be enough on public law grounds if Cérélia was under the impression the CMA was going to find for it on this point, and actually it found against it at the end of the day. That should be a sufficient material error. that should be, you might then have an argument, we're going to have it in a different context about discretion in relation to quashing, etc. But is the duty to consult breached on the facts? If you accept them as I put them, the answer is yes. And if we look at what the tribunal said in relation to this, and again, I accept the point was not put as a duty to consult point below, but it was put as a vault fast point. So the tribunal judgment is in core bundle tab 7. It's paragraph 165 at page 108, it's internal page 65. In relation to Hengline, Cérélia argues that the CMA concluded in its PS that Hengline represents a material constraint on the parties, particularly in relation to competition for smaller suppliers. However, the CMA reached a different conclusion in the decision, stating that Hengline offers only a limited competitive constraint on the parties and no explanation is given for the CMA's vault fast. So that's what was argued below. So the facts are all there, it's just what legal label you put on that. And the tribunal's conclusion is at paragraph 170. And it addresses other submissions in relation to Hengline, but there is no consideration of the vault fast point.
I mean, they did understand that the vault fast point was being made.
That's right. So 165 was our submission, 170 is the tribunal's assessment.
I suppose it could be wrapped up in the last line and a half, but you're right, it doesn't address the argument, it's a sweeping generalisation. The criticisms raised come nowhere close, but it doesn't analyse it.
No, it doesn't analyse it. And I think even if, well, that were correct, you still have my point. If I'm right, and there was a breach of the duty to consult, that's not going to be the answer on this appeal.
Yeah.
And there is, I mean, at the point, the way it was made below, it was made as an irrationality point, that it's irrational for the CMA in the FRs and the consultation document to look at the evidence and say, was a material constraint, and then in the final report, without any sort of new Deus Ex Machina coming in and changing the evidential position, taking the opposite point, and with no explanation of how there had been this vault fast. And that's the way it's put below, and we put it here as well as a secondary argument that it's irrational to do that. No, that's all I wanted to say on grounds 1 and 2, unless you have other questions. And then we'll move on to grounds 3, 4 and 5. And before I go to the individual grounds, I'd first of all like to take you through the relevant provisions of the Act. And I'll take you through the detail, but just two overarching points to begin with. First of all, it's quite clear, as we'll see, that Parliament specifically addressed itself to the need to balance the public interest in granting the CMA powers to intervene in mergers with the public interest in ensuring that such powers are exercised expeditiously so as to limit uncertainty. Precisely what the Act does. And in order to address that balance, as we'll see, what Parliament did was to enact a detailed regime relating to time limits. So that's the first overarching point. Parliament has considered those two competing public interests. And the second point is that the CMA is under a quote-unquote duty of expedition when dealing with mergers. That's a general duty. Again, I'll show you the relevant provision on that. So can we go to the Enterprise Act, please? It's an authorities, tab 1. And I'd like to begin with the duty of expedition. That's at page 36. It's section 103. And if I could ask you please to read section 103.1.
Yep.
So you'll see the heading, duty of expedition in relation to references. You'll see from the provision it's a general duty. You'll see that the overarching duty of expedition is imposed, and I'm quoting here from the section, with a view to the prevention or removal of uncertainty. So that's the public interest in things not being left uncertain for too long. And that reflects the fact that it is important. There is a public interest for the merging parties, for other participants in the relevant markets, and for the process of competition that merger issues are decided quickly. That's the public interest that is being given effect to here and recognised.
It's actually expressed not as a duty to do things expeditiously. It's a duty
To have regard.
have regard
Yes.
to the need for doing things as soon as reasonably practicable.
That's right.
So, I mean, it's phrased in a way that does allow for the possibility that other things might get in the way.
I understand. But there is the public interest to deal with things expeditiously is recognised. There's an obligation to have regard, and you're absolutely right. So, for example, in our specific case, in making a decision to extend the timetable for a phase 2 report, the CMA is under a specific duty to have regard to the need for making the decision as soon as reasonably practicable. That's how the have regard would come in our case, for example.
I mean, it presumably also has to have regard to the need to make an accurate decision.
That's right.
It's just a factor to be taken into account.
That's right, but there is the public interest. As I'll show you, there's a balance throughout this.
Yeah.
Public interest on allowing the CMA to intervene in mergers, that's public interest, and a public interest in proceeding expeditiously. But both are taken account of by Parliament. Can we go next to section 39 sub 1, which is at page 23.
Yeah.
And if I can ask you to read, remind yourself, well, I'll read it quickly. Time limits for investigations and reports. The CMA shall prepare and publish its report under section 38 within the period of 24 weeks beginning with the date of the reference concerned. So a specific 24-week time limit on the CMA. The classic sort of approach to construction. What does the Act not say? Well, it doesn't say that the CMA should publish its report as soon as reasonably practicable. That is not the statutory language. So that tells us that the setting of a specific 24-week time period was an express choice made by Parliament. And the consequences of that legislative choice must be as follows. If the CMA does not produce its report within 24 weeks and does not lawfully grant itself an extension, or doesn't, sorry, let me start that again. If the CMA doesn't produce its report within 24 weeks and doesn't grant itself an extension, lawfully or unlawfully, then the CMA would not have power under this Act to adopt its report at a later period. And therefore, loss of power to intervene in mergers is inherent in the scheme of the Act. Again, that reflects the fact that Parliament has taken account of the public interest in allowing the CMA to intervene in mergers and the public interest in expedition. But it's quite clear that the CMA can run out of time and lose its power to intervene. Section 39 sub 3 on this page, the CMA may extend by no more than 8 weeks the period within which a report under section 38 is to be prepared and published if it considers that there are special reasons why the report cannot be prepared and published within that period. Now again, let's just imagine a case where the CMA has validly exercised its power to extend. Let's assume there's no question about that. So it gives itself an extra 8 weeks and then fails to adopt its report within that time period. Again, it's quite clear from the scheme of the Act at that stage it will lose the power to intervene in the merger. Can we go to section, still on this page, sorry, 39, 4 and 5, sub 4 and 5. The CMA may extend the period within which a report under section 38 is to be prepared and published if it considers that a relevant person has failed, whether with or without a reasonable excuse, to comply with any requirement of a notice under section 109, and then relevant person is defined across the page. So the Act gives the CMA a discretion to extend the period within which it has to report where one of the parties to a merger, that's the relevant parties as defined, has failed to comply with a formal notice requiring the provision of information or documents or the appearance of witnesses. And section 39 sub 8 tells us that that extension shall continue until the information is provided or the CMA decides to cancel the extension. So the Act therefore provides a specific mechanism to ensure that the merging parties cannot cause the CMA to fail to meet the relevant time limits as a result of their actions. It's a protection. But the fact that that protection is in there tells you about the importance of the time limits in the first place, because that sort of protection wouldn't be needed if failure to comply with the time limits didn't mean that the CMA lost power. That's the whole point of that provision.
You're going to come on to what the significance or otherwise the words "if it considers" are, as well as special reasons, presumably.
I am absolutely. I'm going to come back to. All I'm doing at the moment is showing
Yeah,
you the
that's
general
fine.
scheme, and then I'll
And
do.
I just want to check I'm going to have a chance to ask you questions.
You will.
at a later
Plenty
stage.
of chance.
That's
First,
fine.
I promise. Yeah, so the next point, I'd like to go to page 30 of this bundle. It's section 41. You see the heading, duty to remedy effects of completed or anticipated mergers. So this is where a report has been prepared and published. And section 41 sub 1 says subsection 2 applies where a report of the CMA has been prepared and published under section 38. Then I emphasise the words within the period permitted by section 39 and contains the decision that there is an anti-competitive outcome. So there are two preconditions that have to be satisfied before subsection 2 applies, and subsection 2 is the power to adopt remedies. So that CMA's power to adopt a remedy is expressly made dependent upon it not only having published a report which contains a decision that there's an anti-competitive outcome, but also on that report having been published within the period permitted by section 39. So again, the Parliament has made a conscious decision that if a report is prepared outside the time periods laid down, the CMA will not have power to adopt any remedies. It has balanced the public interest in expedition with the public interest in the CMA having powers to intervene in mergers. The next point is at page 39, and it's a provision we've seen before. Section 104 relating to the duty to consult. And you'll see in particular at section 104.4a, in considering what is practicable for the purposes of consulting, the relevant authority shall in particular have regard to any restrictions imposed by any timetable for making the decision. So the duty to consult is made subject to the need for the CMA to comply with the statutory time limits laid down. It's confirming the importance of the time limits. And where there is a tension between the duty to consult and compliance with the time limits, the need to comply with the time limits may water down the duty to consult.
Yep.
And that again, clearly emphasising the importance of the time limits. And I've got one last section to look at, and then I see the time. Page 27. It's section 40, and it's sub 8 and 9. And if I could ask you please to read it, sub 8 and sub 9. Yep. So you'll see that the Secretary of State is given a power to adopt an order which alters the 24-week and 8-week time periods. But the power only works one way.
To reduce it.
To reduce it, not to increase it. And again, that is indicative of the express decision taken by Parliament to set down express time limits and limits that should be complied with. My lords, I think we all deserve
Is
to
that a
lunch.
time, is that a convenient moment?
It is a very convenient moment. Thank you.
2 o'clock, please, thank you.
All rise.